Dear friends, the purpose of this lecture is to help the students pursuing law, graduation in law or master's degree in law. I am a chartered accountant with an experience in teaching. I am basically an academician for 30 years, and during the last 4 years I have been appearing in the courts, Honorable Madras High Court, as party person. So I have done the basic graduation in law, and also now I am doing the post graduation in law. The purpose of studying law is to study in the form to do some research in the law, basically the judicial process. The object of my series of lectures is to share my experience, critical appraisal and analysis, so that it will be of great use to the young budding lawyers. This is only a one-side view, as you are aware that my experience is too small, too little, but then it can be an additional input for all the students. Many students don't have access to the best of the professors, and law is such a beautiful subject, and a real legal knowledge is essence for the vibrant democracy and protecting the constitution. So with this view in mind, I would like to explain you the theory of jurisprudence, the concept of law. I am highly influenced by the American theory of realism. Which is propounded by Holmes, where he tries to say that what is law? Law is nothing but what judges make. It is a law that you have to study in action. The dynamic process is what is taken as this American theory of realism. So now I am trying to link a live case study to the views expressed by this great jurisprudent. And also, friends, there are several things I have learnt, and that could be of great use to youngsters, the budding lawyers. So the first part of the discussion will be when you are appearing before bench. This is basically focusing on writ jurisdiction. My experience is very much limited, or this lecture is basically focusing on writ jurisdiction, and the live case study, the case that I will take up in detail. So this is actually the first case that I have appeared before the bench. In fact, I have not appeared in the sense taking adjournments or just making some mentions, but arguing a case. This was the first time in my life that I was before this bench, Chief Justice bench. It is a writ appeal 1097 of 2012, and that came before the bench of the Chief Justice, their Lordships R.K. Agarwal ji and Paul Vasant Kumar Judge. So before I started this, I would like to mention about the first bench. In fact, I am very fortunate that during the process of writ petition before the single judge, and thereafter admission in the writ appeal stage, and then went to several judges, and I had the best of the opportunity to watch the greatest judges. I am really fortunate. But only in this case, the writ appeal came for arguments and disposal of the case. Now, because the Chief Justice came just, he was transferred, the acting Chief Justice became sometime in March. So I would like to understand, always it is a must that your case, and you have to read the mind of the judge. This is what I felt. And in this particular case, The judge, I have gone through the wide term, the background. He's an expert in the taxation areas, constitutional matters. So it suits me because my case is about education and it concerns Institute of Chartered Accountants of India. Now, before going to it, I'd like to talk about few cases I was observing how it was being disposed of. And if you go today in a matter of 8 to 10 months, we can easily know about any judge because all the lawyers talk about the judges. And today, the Chief Justice Shri R.K. Agarwal ji is rated as the best of the judges. That means there is a great certainty of law. That means you know if you are right on the right side of the law, you are sure to get a relief. Every senior judge, senior lawyers tell you that. And the greatest strength which I found is basically I am a very raw candidate. I don't know much of law. But then this great judge listens to you. He gives you a lot of time and with great concern he listens. He reads your petition and dispassionately. You cannot say whether he is liking what you write or he is disliking it. But he listens to you, he reads your matter, and in spite of the greatest knowledge he has, he takes a good care. Particularly in the writ appeal stage, there is a final stage for us. Otherwise, you have to go to the Supreme Court, and that is the greatest advantage. And anything concerning violation of principles of natural justice, or anything concerns in the public interest, you can be sure of getting relief. Let me give you 3 to 4 instances. So many instances I wanted to watch because I wanted to learn, because I am very much impressed with this American theory of realism, which says that the law is nothing but what the judges do. The law is nothing but what the judges do. Of course, if you go to the natural law or Salman and others, they have different views. As we know, the sources of law talks about the law made by the legislature. Some jurisprudence sit on that. The second thing is precedents, that is the judge-made law. And the third one is customs. But even in the judge-made law precedents, this particular thought is a very, I am really impressed with that thought of Holmes, which says that law is nothing but what the judges make. It is in action. The theory of American theory of realism. So I am trying to connect this entire situation, the case study, the live case study, in line with that particular jurisprudence theory, which I subscribe to in this particular case. So first step is, as a person, you must very clearly realize that you are not arguing the case. Though we say lawyers argue, I would like to say a lawyer must plead his case. Because any legal issue will have so many views. It is not necessary the judge should subscribe to your view. And therefore, when you are presenting the case, you should be very clear that you have to persuade their lordships to see your side of the view. The persuasion skills, understanding the psychology of the judge becomes extremely important, is what I feel. And basically the reason is the judges are extremely knowledgeable, they are so experienced. So therefore, what exactly you are trying to canvass and how it is relevant with the violation of the laws and things which I am going to explain as I go on. So first and foremost step, I repeat that when you bring a petition, that means you are raising an issue and you are trying to say that there is a violation of your rights. Now you should be able to convince their lordships. Remember, it is not a computer, there 1 plus 1 is 2, because here your view is one view out of 100 possible views, and it is not necessary their lordships will be at your side. Maybe, but they may also not be on your side. Therefore, your duty is to plead your case, canvass for your case with the utmost respect to the lordships. And another important point is, This is a very important rule that a young lawyer must consider. You have to think when you are before the bench that the judges are gods. And once you come to that conclusion, then you will be in a position to convincingly present your case. That is very important. First, your duty is to present your case, that's all. And it may be dismissed, it may not be dismissed, anything can happen. This is one thing which every budding lawyer must keep in. You have to prepare. Suppose there are 100 points and you are with 99 points. The judge may look at the other 1 point which is not in your favor. So you have to be prepared for everything. You should not think you will win the case. You can only try your best, and you have to, but you have to give the best shot when you are going. And if you fail, there may be some reason you have to critically appraise, because what is this concept of success is nothing but continuous failures critically appraised is what I have learned in a journey of this trying to teach so many, more than 1 lakh of students I have taught. So friends, now come back to the subject. So first and foremost step is, as you know that you are going to plead, canvass your case before the bench. And you also know that your views need not necessarily be the views of the judges. And it is always better to know the background thinking of the judges, so that you can be sure of your case. You know, you have to do the best possible shot. Suppose a particular lordships are not in favor of that view you are taking, there is no point in taking the case before them. You can wait and something like that, which is being done by all the senior lawyers. So, coming back to this, their lordships, Shri Agarwal ji, entire court in the Madras High Court is, everyone believes that he is one of the best of the judges, and the reason, if you ask them, is one, he listens. He is a very kind judge. He listens to you, and he reads your case in detail. And in spite of the extreme knowledge that he has, he gives consideration to you, particularly because you are at the appeal stage and there is no other appeal for you. Once it is dismissed, you have to go to the Supreme Court, which is not possible to you. Now, I would like to present my observations. I've been observing, I'm learning. In all the courts I go, I sit and observe. But particularly I've been appearing in this court for, remember dear friends, that I have appeared before their lordship for 5, and all my cases were dismissed, honestly. But then I've learned a lot. I've learned a lot. That's why I wanted to share it. A person who has failed can tell you better than the person who succeeds, is what I always believe. Now coming to the 3 issues I'll tell you. The learned Chief Justice. One case, one very senior lawyer was arguing that case concerns crop loans, and the matter was in Tamil. It was translated into English, and since it is in Tamil, he was reading to the other judge, Justice Satyanarayan ji. So when he was reading, the chief was going through the entire case very fast. He reads. After reading that, he asked the lawyer, the counsel who is appearing for him. He said, "You are asking for a term loan. The issue you are raising is about a term loan, a long-term loan, I think. But crop loan is not a tree loan. So how can you? I think the translation is wrong. I feel so." Immediately the case is solved, and because the lordships could have just tracked him down, saying that no, this is what are you talking, this is a simple crop loan for 3 months, you have to repay that, that is the rule. But then he heard him, gave him time, and later on told him, because the other counsel was thinking that it is in Tamil, he is going on explaining. He read it, the Tamil version, and then he said, I think translation is not correct, crop loan means only 3 months loan. Second issue, second case I was there. One very senior advocate, senior party person, I think around 70 years, he filed a petition, and issue mandamus to Parliament to make the Chief Minister of Tamil Nadu as the Prime Minister. That was the subject matter of the petition. Justice Satyanarayana was shocked to see that petition and he said it's dismissed. Then this party person, the senior gentleman, he said, what happened? I'm not able to hear. Can you please tell me? The chief looked at him for some time and he didn't say anything. And then he said, okay, we'll issue notice. He kept quiet. Here, anybody could have dismissed, anybody could have criticized the party person who is a senior gentleman. He could have fined him also for wasting the time. But this great judge realized that the practical issue, anyway issuing notice is not going to make anybody, court has no power to issue mandamus in these cases. But then since that senior gentleman had come, he was practically a little lenient, kind, I could say. He was so kind. And in another case, it came before my case came in. It's again Institute of Chartered Accountants of India, where there is a disciplinary case where the chartered accountant married another lady. It's a bigamy, and then he was punished for that 6 months disciplinary case, removing from the membership. The senior counsel was saying that bigamy is not as an offence. Like that, he went on vehemently arguing it. He tried to take out the list of the offences that are considered. But chief told him that you please give me a Supreme Court judgment which says that bigamy is not an offence. Then I will take up the matter. And what exactly a chartered accountant is a person whom the public trusts. So he has to conform to the rule of law. And he was very strict. And the judge wanted, the senior counsel wanted to take time, but he gave him only 1 week's time. And then he took the call on that. So coming to, this is the background which I have analyzed. So I am a raw candidate, and when your number is called, you will be shaking because the first time I am appearing, I didn't know. I know Justice, I have already appeared before Justice Paul Vasant Kumar. He was a great judge and he is so kind, fast and is to the law. And the entire court adores him for his honesty. But then the case started, my case. I didn't know how to get going with this case. So I started, I immediately took the thing and asked I'll talk about the case now. But what I'm trying to say is, I was given first day 35 minutes. The Lordships with so much knowledge, everything, he listened to me. Though Paul Vasant Kumar judge was clear, he was of the view that I don't have locus standi to move that mandamus. But their Lordships heard me, and which I will try to present my case now. And next day again he heard me for 25 minutes. And later on the case was resolved for judgment, which I'll brief the entire case. The case was resolved for judgment, and on 29th April the judgment was passed dismissing my appeal. I thought everybody told that I performed very well, and I felt that I get a good chance of winning the case. But when the case was dismissed, then I didn't take it to my heart, but I thought if the judges were not in like of the case, they could have dismissed it. They did not have heard me for such a long time. So their view, let me apprise it. So I went for a review petition, and I have learnt a lot, but review petition was also dismissed. But then, when I explain you all these three issues, you will realize how you can approach your case, what is mandamus, and how to present yourself, how to learn from the experience. This is the purpose of my lecture. Now coming to the case. This case, briefly, my friends, is This is Professor Manubai Shah's case, where Professor Manubai Shah was from Gujarat. He did some research. Media he has got, which does research, and through that research he came to the conclusion that life insurance corporation is charging exorbitant premiums, and they are investing in dead investments, and therefore he came out with a claim saying that LIC is playing fraud on the nation. LIC is playing the fraud on the nation. And he, with all his supportings, he went before the Supreme Court, went before Hindu, the leading newspaper. So that it was published, a full page article by Hindu with a caption that LIC playing fraud on the nation, the policyholders. To this, what happened, the LIC managing director gave a rejoinder, saying, refuting the allegations made by Professor Manubai Shah. And that was also published by Hindu. And thereafter, what the LIC did is they published one Yoga Kshema. It is an in-house journal. In that, the views of the managing director alone were published. Views of the managing director were alone published in this. And the Manubai Shah also wrote a letter asking them to publish his side of the view, for which the LIC has refused. So he moved the Gujarat High Court, and Gujarat High Court agreed with Professor Manubai Shah's petition, against which the LIC appealed to Supreme Court, and Honorable Supreme Court analyzed the case. Both Gujarat High Court and Supreme Court were in favor of Manubai Shah's case, and they have analyzed Article 19 and Article 14 of the Constitution very, very well. Now, that is, we'll take up that matter, but this is briefly the case. What the Supreme Court in short said was that here is Mr. Manubai Shah found certain mistakes, and is supported with the research. Now this LIC has refused without giving reasons. In a democracy, Article 19 talks about a citizen, vibrant democracy can survive only when a citizen is presented with two sides of the issue. It is for the citizen to decide what is right, what is wrong. Now here, in the information, one side of the coin is what LIC is talking good about it. But they don't want something which is not palatable to them, which is violative of Constitution, Article 19, 1A. I will come back to you in detail, but this was the view. Suppose, for example, LIC had certain reasons for refusing it, they must have given reasons for rejecting it, which means that not giving reasons is violative of Article 14 of the Constitution. So, we have a brief view about this Professor Manubai Shah's case. In short, Professor Manubai Shah has requested the LIC to publish his side of view, which LIC has refused to. So the Honorable Supreme Court expounded the law that LIC is a state body, state instrumentality, therefore the funds belong to the state. In other words, the Yoga Kshema that is published by LIC belongs to public. Point number 2 is, now one side of the view has already been published, which is very palatable to them. Then when the other side is to be published, they are refusing. So the court took the view that we should, the LIC must have given reasons for not publishing it. That is violative of Article 14. And according to Article 19, 1A, we need both sides of the view. So I read this when I was studying my law, and I am actually a teacher and teaching for CA students for a very, very long time. The cost accounts and financial management are the two subjects which I teach. As you all know, the public thinks chartered accountancy exam is very, very tough, and it is really difficult to pass the exam. And they also believe that the institute maintains very, very high standards. This is what everybody feels. But from 95 onwards, I used to watch that the CA Institute used to do so many mistakes, honestly. Suggested answers, the first what happens is they will give exams. They conduct exams very well. You cannot copy the CA exams. That much is excellent. But when it comes to the situation of setting the papers, they were only setting mistakes and mistakes. And the suggested answers, what happens? Let me give an example. The same question will be asked in 3 exams, same question. And the suggested answers will publish 3 different answers, because that is the base on which a student prepares. So I used to bring it to the notice of the institute by writing letters and all. From 90 onwards, 95 onwards, they were very arrogant. They believe that they are the best. Who else can talk to them like that? So we can only write to them. Only when I started learning law, then I thought the remedy lies somewhere. That is, the Honorable High Courts will settle these people's arrogant behavior. So, incidentally, what happened in November 2011 CA exams, there were about mistakes to the tune of 48 marks. 48 marks were mistakes. And the institute suggests, publishes opinions of the examiners, that is, those people who have evaluated the papers. They will say question by question, students did not understand this, student did not do this, that, this. Let me give you a simple question. The institute asked a question in financial management, that a person is having shares market value 5,300 debentures. A person, an investor, is having debentures worth 5,300 rupees. That means if you sell now, you will get 5,300. They are convertible debentures. That means they can also give the debentures to the company, in which case the company will give 10 equity shares. But equity shares are priced at 430. In other words, 10 equity shares, it will be equal to 4,300. So the investor has the option. One is to sell it in the open market. He will get 5,300. If he gives it to the company, he will get shares worth 4,300. That is the problem. And the institute asked them, calculate the premium. That's all. They were carrying 6 marks for this question. And institute, what they have written, the answer, the suggested answer, 5,300 minus 4,300. 1,000 rupees is the premium. That's all. So I asked them to raise the question, how a person who can get 5,300 will sell it for 4,300? Nobody, no fool will do that. The second question is, it is discount, it is not a premium. Second is, they themselves admitted some mistakes in transfer pricing. A host of mistakes, this is happening. You can see, I have made analysis. Institute says a problem. The quantity risk-free security. What is the risk-free security? A security which has no risk. That means the value is 0, risk-free security is 0. But institute in every problem gives 1. Beta value of risk-free security is 1. So I asked them, how can risk-free securities have 1? It should have 0. Then they said, oh, we never knew it. These people are not knowing it. Okay, next time we'll correct it. So what I did is, I wrote a letter to the institute bringing out all the mistakes. And I asked them, see, you have published one side of the view, that is the examiner's view. I am saying, examiners did not know anything. Whatever you are giving, they are just calculating, because nobody is bothered, you are projecting yourself as the most toughest exams, that's all. So immediately the president, one Mr. Jaideep Narendra Shah came to Chennai and he has admitted that there are a lot of mistakes and also assured in future he will correct it. Then I asked, sir, you are failing students by getting 1 mark less. Most students will fail getting 39 marks.